Good morning, ladies and gentlemen. Welcome to the celebration of the United States Constitution. It's September 17th, and today is the 232nd birthday of the United States Constitution. So we're here to celebrate the founding documents that have been so durable and guided us and created a nation that is the rule of law rather than the rule of individuals, and has been a main contributor to the freedoms that we enjoy as Americans. So that's why we are gathered here today, is to celebrate that legacy and maybe hopefully become more informed about the actual document itself. But before we begin our program today, I did want to thank, this is a great attendance, what a packed house. Thank you to my colleagues, so many of you that brought your classes and encouraged them to be here. We want to start, though, with the EFSC Concert Choir under the direction of Robert Lam. Please give it up for them, folks.
We begin with our national anthem. It's an arrangement that we sing, so it won't really work if you sing along, but I would love you to stand and be there with us.
Oh, say, can you see by the dawn's early light, so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets ran glad, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you. You may be seated. We sing now a selection that features piano and our accompanist, Sally Cook. Thank you very much. It's a medley of American songs. Hope you enjoy it.
America, God shed His grace on
Ladies and gentlemen, Dr. Robert Lam, Sally Cook, and the Eastern Florida State College Concert Choir. Can we please give it up for them one more time? Thank you so much. And again, I want to thank all of my colleagues, too many to name, but thank you for coming. Administrative officials, students, so glad that you are here. And of course, again, all of my esteemed colleagues, thank you for being here. Because we are here today as a birthday party. And oh, by the way, we are being streamed live on our website, and thanks to the EFSC TV production crew. They always do a fantastic job. Thank you for being here today as well. But we are here to celebrate a birthday. Ladies and gentlemen, the birthday of the Constitution. Can you believe it? 232 years old today. Doesn't look a day over 231. But 232. Unbelievable. That's my contribution to the music, ladies and gentlemen, the air guitar. That's just me, though. But yeah, again, 232 years, it is hard to believe that it has endured that long and has served as the guiding standard for our nation and for emerging democratic societies all over the world. What I find interesting about the Constitution is in recent polling, 75% of the American people say that they love and revere and venerate this document, the Constitution of the United States. And that's pretty exciting because we can't find the American people coming together and 75% of us agreeing on just about anything. So the fact that we are unified in our adoration of the document, I think, is very exciting. I know that other people around the world, in other countries, they kind of are fascinated by this. You can see the headline here. Maybe we're obsessed with the Constitution. But again, that's the tie that binds us because we are very divided. Let's not forget that. We are very divided as a country. It is true. Republicans don't want more government. Democrats overwhelmingly want more government intervention. We're divided on that question. Gun control, that's a big issue. Democrats encouraging more gun control legislation, Republicans opposed to it. We're divided. One good thing is Judge, I'm happy to report, we have a more favorable view of our Supreme Court. 53% of us are now in favor and support the Supreme Court of the United States. But what has become my favorite graph of all time, when we break it down based upon our party identification, it tells quite a different story. As you can see in the year 2000, right before the election, 70% of Democrats had a favorable view of the court, while just about 60% of Republicans did. After the 2000 election, 42% of Democrats liked the Supreme Court and 80% of Republicans liked it after the election of George W. Bush. After George W. Bush appointed 2 members in 2005, the approval among Republicans went to 75%, went to 48% among Democrats. When Barack Obama was elected in 2008, though, magically, 75% of Democrats began to enjoy the Supreme Court, and Republicans decided they didn't like it anymore. When Donald Trump was elected president, only 18% of Republicans liked the Supreme Court, but magically overnight, 72% like it now. Kind of fascinating. We are very divided. We, the people, we are divided. But there is one thing that unites us, and that, of course, is what we're here to celebrate today, our founding document, the United States Constitution. And to help us become more familiar with this document, its history, and what it means to us as Americans, we have a very distinguished guest that I'm going to have the honor of introducing to you this morning. Our distinguished guest and keynote speaker today was first elected to the Brevard County as a Brevard County judge in the year 1998, and has been subsequently reelected in the year 2004, 2010, 2016 without opposition, and I'm assuming again in 2022, thanks to Amendment 6 that we all voted for last election. Will allow our guest to run for another term. In 2014, our speaker was elevated by the Chief Justice of the Florida State Supreme Court to serve at the 5th District Court of Appeals to fill a vacancy there. In 2009, our guest was given an honor of the most outstanding jurist by the Brevard County Bar Association. In 2003, he was named Mentor Judge of the Year. From 1998 until 1994, or 94 to 98, he served as Assistant Public Defender, the capital case division of our Public Defender's Office, defending the indigent for their ability to have a fair trial. Before that, 1981 to 1986, our distinguished guest was the Assistant State Attorney Felon Division Chief. Our distinguished guest holds a Juris Doctor from Loyola University School of Law in Chicago. Getting to know our distinguished guest, I can tell you personally that he is a gentleman, a scholar, and he really knows what it means to be a public servant. Please help me welcome the Honorable Judge David Silverman. Please, ladies and gentlemen. There you go.
Morning, folks. Morning. Can you hear me now? Very well. Thank you, Professor Murrow, for those overly kind words. Administrators, officials, trustees, faculty, alumni, and students of Eastern Florida State College. I am grateful and humbled and honored to be able to appear before you on Constitution Day. Before I went further, I wanted to thank Professor Lam and the choral group for that inspiring presentation and for his instructions not to sing along, because I was ready to. The flyer about this presentation said it would be interactive, and I'd like you to go ahead and hold your questions to the end. I do hope to have some time to answer them. I will have some questions for you. I also have some, if you're called upon, you give the right answer. I've got a protein bar for you that my assistant will hand out. As Professor Murrow said, we're here today to celebrate the Constitution of the United States that was signed 232 years ago today. And technology is wonderful when it works. Oh, there it is. I didn't press it hard enough. Thank you. Thank you very much.
My pleasure.
The Constitution is on public display at the National Archives Museum in Washington, D.C. If you looked at it today, you would see a faded, barely legible set of parchment pages from the 18th century, handwritten in iron gall ink with a quill pen made from a goose feather. Transcending this fragile vessel, the Constitution's revolutionary words have thundered through the halls of power in this country for over 200 years. Our Constitution has weathered political upheaval and civil war. The government it established, the most successful democratic republic ever conceived, survives to this day. The vision of those who wrote, debated, and finally signed that parchment has made our Constitution a document for the ages. the Constitution has become America's conscience. As American citizens, we have at various times lived by its commandments, ignored its wisdom, reconciled its message to unimagined social, moral, economic changes, and each new generation has discovered the strength and the challenges behind its opening words, "We the people." Delegates from every state except which one? Which state didn't send a representative to the Constitutional Convention? Anybody? Yes. Rhode Island. That's good for a protein bar. Met at Independence Hall in Philadelphia in the summer of 1787 to address the deficiencies in the Articles of Confederation, a league of friendship among states that had struggled over the preceding 6 years to generate the semblance of an organized government, but which had proved weak and inefficient. If there's any further need of proof, it's difficulty in dealing with the rather paltry rebellion of unpaid war veterans and indebted farmers, reluctantly led by whom? Anybody? No. A rebellion against the Articles of Confederation just before the Constitutional Convention. Yes. Daniel Shea. Lisa? That's correct. Now, that would have convinced any reasonable observer of the need for change. However, rather than making piecemeal changes, the delegates, meeting in secret session, undertook to create a whole new governing system, one with a much stronger central government to meet the needs of our future country. And from their labors was generated the most enduring written constitution the world has ever known. Now, before proceeding further, I wanted to say a few words about the principal architect of this remarkable document. Who can tell me who that is? Anybody? Yes? James Madison, that's correct. He came from the Virginia aristocracy, being a son of a planter who owned 5,000 acres and about 100 slaves. He was educated at a boarding school in what later became Princeton University. Madison was only 5 foot 4 inches tall and about 100 pounds. He was a shy and soft-spoken and a rather lonely bachelor of 43 when he asked his friend, Aaron Burr, to introduce him to the 26-year-old widow he wanted to meet, Dolly Payne Todd, who later became Dolly Madison. Madison was accomplished. He read Latin and Greek, and he was an ardent chess player. There's some evidence that Dolly played chess as well, and there's good evidence that her sister, Anna, played. Jefferson once referred to her as the chess heroine. Madison would play even on Sunday, indicating that he thought it was more than just a trivial diversion. His games with his friend Jefferson were often 4 hours long, epic battles. In Jefferson's library, there was a book by André Philidor, a Frenchman who is the greatest chess player of that era, a book that advocated strategic play rather than the more romantic gambits that were then in vogue. In an era where pawn sacrifices were common, Philidor wrote, "Pawns are the soul of chess." Franklin also played chess, and he had his copy of the book autographed by Philidor. And although the records of the moves have not been preserved, we can conclude that Madison's chess games were characterized by careful, patient, positional play. He was planning ahead, anticipating, playing for the end game, rather than some dashing tactical combination. I mention this because Madison's chess is analogous to his deeply insightful, persistent efforts at the Constitutional Convention. In addition to drafting the basic outline for the Constitution, he was instrumental in persuading other delegates to accept its provisions, sometimes at late-night strategy sessions that involved Madeira and rum. And together with Hamilton and John Jay, Madison was also a principal architect of the Federalist Papers, promoting the ratification of the Constitution by the states. He also drafted the Bill of Rights. Who can tell me what the Bill of Rights is? Yes? The first 10 amendments. Lisa? Tell me what your favorite amendment is. Tell me an amendment. The First Amendment. What's in the First Amendment? The freedom of speech. There's something else in the First Amendment. Who can tell me what? Yes. Freedom of petition. That's one. Go ahead. Something else? Yes. Freedom of assembly. That's correct. Who can tell me another one? Yes, in the far back. Freedom of religion and the prohibition on the establishment of religion. Yes. Freedom of the press. That's correct. I was about to ask for another one. Go ahead. You anticipated the question. Very well. Lisa, if you could go ahead and... Madison's later concern that the limited government he favored was swelling into a monolith favoring the wealthy interest placed him in league with Jefferson and opposing Hamilton, whose policies he objected to and who he disliked personally. Hamilton's picture is on the $10 bill. Who can tell me what denomination of bill, still legal currency, that James Madison's likeness is on? Anybody? Yes? No? No, that's Jefferson. No? No?
Are you sure?
Okay, you probably don't have it in your wallet. Anybody? I couldn't quite hear it. No, not 1,000. No, you're just guessing now. No energy bar on that. The $5,000 bill, they stopped printing it years ago, but now there's one other contributor I'd like to mention. Gouverneur Morris was a delegate from Pennsylvania at the Constitutional Convention. Now, he was a member of the 5-person committee on drafting called the Committee of Style. And Morrison infused into the Constitution his own vision of a strong central government, perhaps the clearest of any delegate, and to the extent that he could, his unremitting hostility to slavery. Now, Morris was brilliant. He enrolled in what became Columbia College at the age of 12, and he was a character. The official version of how his left leg came to be replaced by a wooden peg is that he fell from his carriage when the horses bolted and his leg was crushed by one of the wheels. That version is disputed by credible sources, summarized by one historian who relates that Morris was known to have romantic affairs, and fleeing a jealous husband, he startled the horses as he was boarding the carriage. You have to remember the founding fathers were not Olympian gods on marble pedestals. Morris drafted the preamble, beginning with the words, "We the people of the United States." This envisions one collective government rather than a union of sovereign states. And the blessings of liberty secured to ourselves and our posterity would seem ironic in light of its tolerance for slavery. The finely wrought phrases that Madison and Morris used in drafting the Constitution and the Bill of Rights were clear and direct, yet flexible enough to be adapted to changing circumstances. The quality of the language contributed to the strength and durability of the Constitution. For example, had the language been overly precise and exacting, the document may have quickly become dated. On the other hand, had it been overly vague, it would likely have lacked the force that it carried. Our founding fathers were students of the Enlightenment, an intellectual movement that advanced the common good of the people as the legitimate foundation of government. This challenged monarchy and the other old traditions under which the American colonists had been ruled. Who's this? Enlightenment philosopher, yes. John Locke. John Locke and other Enlightenment philosophers asserted that using reason and logic, people were able to establish for themselves a mechanism that would protect life, liberty, and property. When our founding fathers talked about checks and balances, what they had in mind was a clock, an instrument with balanced weights and counterweights operating with precision based on scientific principles. The Constitution produced by the Convention did not include the freedoms and rights such as freedom of speech, the right to a fair trial that most typically come to mind when people think of the Constitution. 3 of the delegates wouldn't sign because these were not included. But Madison and the other founding fathers knew that if they did not establish a protective foundation, their legacy of rights and freedoms would be mere aspirations, swept away by the political passions of the moment. Let's consider the example of the French Revolution that occurred a couple of years after the Constitutional Convention. The French Declaration of the Rights of Man and the Citizen reflected many of our same values. Who can tell me the motto of the French Revolution, which is now the national motto of France? Liberté, égalité, fraternité, right? Lisa? Well, freedom of speech was not unique to America, right? Having the same rights and freedoms, why then did the streets of Paris run red with blood from the guillotine in a reign of terror? Our founders knew the value of an independent judiciary, one that was above political whim, and to achieve that, they mandated that federal judges be appointed for life. The judges in the French tribunals were merely engines of the revolution. Untethered to law, they were prepared to convict and execute anyone suspected of being an enemy of the people. That phrase was used extensively in the French Revolution. A leader of the French Revolution, Maximilien Robespierre, once stated, "The revolutionary government owes to the good citizen all the protection of the nation. It owes nothing to the enemies of the people but death." Our founding fathers were not ideologues. They were savvy businessmen and politicians. The separation of powers and the system of checks and balances comported with the founders' dislike and distrust that they felt toward each other. In the case of Alexander Hamilton, that animosity ended in his violent death at the hands of Aaron Burr. However, being practical and pragmatic, they also understood the need for compromise. The Constitution has often been called a living tribute to the art of compromise. One such compromise resulted in a legislative branch with deliberative bodies, one house based upon population and the other the Senate, where each state was represented equally. Who proposed that compromise? What delegate did that at the Constitutional Convention? Anybody? No? Yes? No? Roger Sherman is correct.
Who was that? Roger Sherman. Who said that?
Roger Sherman.
Oh,
The convention included, of course, representatives from the South, where slavery was an institution that sustained the economy of the region, a region where it was a given that its agriculture would be impossible without slave labor. If the new nation did not guarantee the continuation of slavery, it was an open question whether the southern states would form their own nation. A compromise was reached, eventually abolishing the importation of slaves, accounting for slaves with respect to congressional representation, facilitating the recovery of escaped slaves, and permitting slavery to continue. This was a compromise with a terrible, a monstrous injustice. The seeds of the Civil War were sown in the compromises of the Constitution on this issue. The framers were not oblivious to the failings of the Constitution, but trusted that in the future people of decency and common sense would work together harmoniously to overcome them. As Benjamin Franklin said in his last speech to the convention, "I agree to this Constitution with all its faults." They knew that the document was imperfect and would need to be changed. And they provided two means for changing it. One was by amendment, a process where Congress and a sufficient number of states would concur in an amendment, a process that has occurred only 27 times in our nation's history. The first 10 amendments being enacted contemporaneous with the ratification of the Constitution. What's the other means by which the Constitution provides for changing it? Yes. What's that? No, abolishment of the Constitution, not exactly, not quite. Anybody? No? Another means, yes, am I missing someone? Another convention, a new constitutional convention. Yes. Put your hand up, would you? Thank you. Oops, excuse me. Now, I think that's suggestive, that our founding fathers were willing to see their entire creation here scrapped if their experiment in democracy failed, by setting up that other means of a new constitutional convention. Now, wholesale changes were not necessary, in part as a result of the role of the Supreme Court. In a pivotal moment in our history, in the court in Marbury versus Madison, in an opinion by the Chief Justice. Who is that? Judge Judy. No, it was John Marshall. That's correct. John Marshall held that the Supreme Court had authority to invalidate a law passed by Congress when that law contravened a provision of the Constitution. Writing as though it was just merely a matter of common sense, Marshall stated, "It is emphatically the province and the duty of the court to say what the law is." It was announced as a matter of the court merely laying the Constitution and the new enactment side by side to see if they conflicted. However, the process of judicial review inevitably involved interpreting the language of the law and the language of the statute. It enshrined the Constitution as the supreme law of the land, superseding any contrary law, and it also established the Supreme Court as the principal interpreter of that law, providing the court with the authority to adapt, to expand, to constrict the meaning of the Constitution to the circumstances as presented in each case. By this process of judicial review, the Supreme Court has interpreted the Constitution in ways that have profoundly impacted our country. I'd like to review with you just a few of those landmark Supreme Court decisions. The Supreme Court addressed the unresolved slavery issue in the case of Dred Scott versus Sanford. In an opinion by Chief Justice Roger Taney in 1857, the court ruled that a slave would not be declared free even though he had resided in a free state and a territory that had prohibited slavery. Taney concluded that African Americans could never be citizens of the United States, and the Missouri Compromise, which had excluded slavery from northern states and western territories, was unconstitutional. That decision added fuel to the sectional controversy and pushed the country closer to civil war. Among constitutional scholars, Dred Scott is widely considered to be the worst decision ever rendered by the Supreme Court. It's been cited as the most egregious example of the court's history of wrongly imposing a judicial solution onto a political problem. Following the Civil War and the passage of 3 constitutional amendments establishing the equality of African Americans, the Supreme Court in Plessy versus Ferguson invoked the controversial doctrine of separate but equal to validate racial segregation laws that provided for separate and supposedly equal public facilities and services for African Americans and whites. Plessy served as a controlling judicial precedent until it was overruled by the Supreme Court in 1954 by Brown versus the Board of Education of Topeka. In Brown, the United States Supreme Court finally ruled that racial segregation in public schools violated the 14th Amendment to the Constitution, which prohibits the states from denying equal protection of the laws to any person within their jurisdiction. That decision declared that separate educational facilities for whites and African American students were inherently unequal. The court's interpretation of the Constitution gives new meaning in circumstances not distinctly contemplated by our founding fathers. For example, in Roe versus Wade, the court struck down a Texas law restricting a woman's right to terminate her pregnancy, a right which the court held, a statute which the court held violated the fundamental right of privacy that the court implied from the Bill of Rights and from the 14th Amendment. However, the court balanced this right against the government's interest in promoting women's health and protecting the potentiality of human life. The opinion set guidelines permitting the states to restrict a woman's right to choose in later stages of her pregnancy. Who authored that opinion? Anybody? What justice is that?
Right here, Kyle.
Close enough. Harry Blackmun. Yes. Justice Harry Blackmun authored the opinion. He had represented the Mayo Clinic and was attuned to the issues regarding women's health on this issue. And the opinion has later been modified, but not overruled, and it stands as today as one of the court's most controversial decisions. In Obergefell versus Hodges, the Supreme Court struck down same-sex marriage bans as unconstitutional, contrary to a fundamental right to marry that was essential to our most profound hopes and aspirations. Religious and traditional family groups criticized the decision in Obergefell, asserting that the court, again, was making social policy. At the time the decision in Obergefell was rendered, however, 37 states had already permitted same-sex marriage or a civil union equivalent. In Citizens United versus the Federal Election Commission, the court held that the First Amendment protects the right to make political contributions, contributions by people and contributions by corporations. Contributing money is often the only way someone can express their political beliefs. Whether the goal is enactment of legislation or the election of a candidate, money is often the key to competing in what Justice Oliver Wendell Holmes Jr. called the marketplace of ideas. Our Constitution's framers anticipated that the forces of power, privilege, and greed may seek to subvert our government. However, the court in Citizens United reasoned that in the internet age, the public should be able to inform itself about corporate-funded political advertising and identify whether elected officials are in the pocket of some moneyed interest. Consistent with that view, that contributing money is an expression of political speech, the court later went on to strike down contribution limits to political action committees. In the years since Citizens United, these committees have taken in millions of dollars in anonymous, dark money that comes from corporations and a relatively small group of wealthy individuals, permitting them to exert an outsized influence on local, state, and federal elections. This money is typically spent on negative advertising and campaigns of disparagement, only often tenuously tethered to truth. Opinions may differ as to whether Citizens United endangers the integrity of our electoral system, but the Supreme Court's ruling in Citizens United has definitely changed the way we choose elected officials. In Federalist 55, Madison asked the question, from what quarter does danger proceed? We are at a moment in our history when our nation is facing extraordinary perils. Increasing racial and religious animosity, the degradation of our environment, the resurgence of potent and addictive narcotics, terrible, tragic school shootings, the devastating effects of climate change, the violence of terrorism and the price of its suppression, the pervasive, electronic and digital surveillance, the proliferation of nuclear weapons, the implications of genetic engineering. Serious dangers that invite the question, will our Constitution continue to preserve the democratic values we cherish? Or will the individualism, the equality, the liberty, and the justice embodied in our Constitution become merely outdated vestiges of a gentler time? As I pondered this question, I came to believe it was the wrong question. The question is not whether the Constitution will continue to serve us, but whether we will live up to the Constitution. Our fundamental rights cannot be taken for granted, or they will incrementally, one step at a time, become as faded as the handwriting on that parchment, until we find ourselves and our descendants living in a country devoid of values cherished by our founding fathers. The Constitution doesn't work automatically. Each generation of Americans has brought forth leaders, men and women dedicated to a cause greater than themselves. They've been willing to sacrifice their lives and their fortunes to preserve our Constitution and the way of life it has engendered. How many of you have been to the Moore Justice Center, the main courthouse in our county? A lot of you have. Now, in courthouses, you would typically see a symbol of justice. I expect you've seen it. An ancient Roman goddess, Justitia, blindfolded, holding scales aloft in one hand and a sword in the other. The statuary relief that greets visitors to the Moore Justice Center also has scales, but the scales are not balanced. It depicts Harry and Harriet Moore, civil rights pioneers, reaching up, straining to balance the scales of justice. They're accompanied by their children and at their family home in Mims that was destroyed by a dynamite explosion on Christmas night, 1951. One message from that unique sculpture is that justice does not descend majestically from above, but that it emerges from the struggle inherent in our adversary system of justice. Constitutional rights don't come easy. Will we rise to the challenge of keeping our Constitution vital so that it may guide us in these perilous times? There's definitely cause for concern. There is an unreceptive apathy entrenched, ingrained in our society, where a third of the adults cannot name the 3 branches of government, where many people don't read anything longer than a tweet and live in digital echo chambers, listening to only what they already believe. We are living in an increasingly polarized society where the people defining their residence as a red state or a blue state, a society divided to the point where for many people, if someone expresses an opinion different from theirs, he or she is their enemy. Where the notions of compromise so dear to our founding fathers is dismissed as feeble and pathetic. But there is hope. More than hope, a reasoned expectation that we will overcome these dangers while preserving our constitutional values. And the cause for that hope is here in this room. It will take character and courage and sacrifice for you to take a stand that upholds our Constitution's values, that promotes the rights and the welfare of your fellow men and women. I submit to you respectfully, that is your responsibility. It's a responsibility that comes with education. With learning and developing your talents and obtaining your degree comes the opportunity and the obligation to provide leadership, and service to your community. And you need to start somewhere. Whether it's handing out food at the Daily Bread, or protecting the endangered sea life in the Indian River Lagoon, or any other opportunity to volunteer. To commence your journey into the future while hearkening back to the principles, the humanity espoused by our founding fathers. Students, let me suggest to you that when your journey ends, as it must for each of us, you should be able to square off to your conscience, hold your head up high, and say to yourself, I did my duty. I'd like to close by sharing something with you. It is a poem written by a poet who lives here in Brevard County and whose name is Joanna O'Keefe. And after I read it, I asked her, and she agreed for me to share it with you in a presentation if the occasion arose. Now, she wrote it more than 5 years ago in a book of poetry. And you might not be able to read it on the screen here, so permit me to recite it to you. We the people are on opposite sides. We've lost sight of the middle where resolution resides. If Jefferson could speak, he would pick up his pen. On parchment he'd write, be patriots again. Look into the eyes of your sister and brother. Be Americans. Respect one another. No outside force will ever take this land, but a house divided cannot stand. Blood has been shed for this land of the free. Be Americans. Embrace your destiny. Be that city upon a hill. Be that light. Lay down your anger. Be Americans. Unite. Thank you, folks. It's been a privilege.
Thank you, Judge Silverman. Thank you. We have just a few minutes remaining. We'd like to take a question or two. If anybody had a question for Judge Silverman, we'd love to hear from you.
Yes.
Please.
What does it mean to you to be a judge, and what kind of relationship do you have with the Constitution?
What does it mean to me to be a judge, and what relationship do I have with the Constitution? I think the hardest part of being a judge is subordinating your own feelings to the requirements of the law. I mean, if judges were to decide cases based on how they feel about it, there'd be a different decision in every courtroom, wouldn't there? So what I have to do is I have to understand what that means, and that sometimes involves some research and study, but then to follow it regardless of where it leads me. So I think that's my relationship to it, I believe. So that's a legitimate question. Any other questions?
Thank you.
Yes? Change anything in the Constitution? You know, there are many scholars who feel that we should have a new constitutional convention because we have struggled to embody rights that were not even contemplated by our founding fathers. The right to an education that all of you are enjoying here, the right to health care. There's other rights that would be important to our society today that are not part of the Constitution. So I think that we have gone along different paths by virtue of its interpretation, but it may be a good idea to actually enshrine those into the Constitution at some point. Yes?
Your Honor, can you tell us how you look at originalism and how that can structure the kind of society we have, even how originalism affects you on the bench dealing with the Florida Constitution?
It's a question about originalism, which is a means of interpretation that harkens back to the original intent of the framers, which is very difficult to discern and to apply in any given circumstance. The language that they were using was very different from today. And so I think it is an answer for a judge to say this was just not contemplated by the Constitution, and the Constitution doesn't address that issue. But oftentimes that's not what the Supreme Court has done. It is, as I quoted in Roe versus Wade and Obergefell versus Hodges, they have found that applying the principles that were enunciated to those circumstances They're only going to deal with the very issues that the Constitution addressed, because from our very beginning, we have been addressing, we've gone along addressing circumstances. We view it, for the most part, as a living document, as opposed to some static definition that the original founders had. Yes? My favorite amendment of the Constitution?
Least favorite.
My least favorite. Oh, I don't have a least favorite. I think that if you ask lawyers and judges, what one would they typically say? Anybody? They say the Sixth Amendment, where there's a right to, yes. I get just 1 second. The Sixth Amendment provides the right to counsel, right? Keeping lawyers and making sure you have a fair trial, and it has another provision, because the founders knew people didn't want to come to court, a right of compulsory process to make them come in, right? Now, if the Fifth Amendment means anything, here's what it means. It means that the prosecutor in a criminal trial doesn't say, he didn't testify. What did we hear from the defendant? Eerie silence, to infer guilt from silence. It is part of our heritage that we're not going to compel someone to testify against themselves. We're not going to torture them into doing that. We're not going to punish them for doing that. And that's an important part of our law. So my feelings about it, and people ask me this from time to time, as I say, my feelings are subordinated to what the law requires. And it definitely requires that, because in an adversary system, everybody wants to win, right? Lawyers want to win their case, but the Constitution imposes limits on what they can do and say in the courtroom, and it's up to me to ensure that those limits are enforced. Any other questions? Yes?
How do you feel about no one running against you?
No one wants to run against you, Judge
Well,
Silverman.
Let me say this. I spoke to there's another judge, friend of mine, Judge Majid, who was a judge here for many years, and I was concerned as to whether I would have opposition in the next election. And he said to me, David, what I wouldn't give for one more contested election. I think contested elections are good, and I acquired a seat by election in 1998. Now, you're right, most judges are appointed and then have to run thereafter. But I think it is a good thing to have the public have the opportunity to elect judges. I think that's a positive thing, because if a judge is really deficient, that may well become known to the public. Now, as I say, I think there's a concern about the public being informed. How do you learn how a judge is doing? It's difficult, isn't it? You have to get meaningful information. You have to really search about that. And that system can be skewed by the influx of this anonymous, dark money, often just negative campaigning that on behalf of some moneyed interest, often challenging some judge. It hasn't happened much in Florida, but challenging someone on a completely unrelated issue. In other words, if it's the insurance lobby that's seeking to unseat a judge, they may say that judge is soft on crime, right? And it's easy to select some case that a judge ruled on where the judge was ruling on the law, and it may give the appearance of being siding with some criminal.
Judge Silverman, I do have to say I have to conclude, because I know students have to get to other classes.
And I apologize for keeping you late with my
But
answer.
let me, please, ladies and gentlemen, Judge David Silverman. We also have the Florida Brevard County Supervisor of Elections is here to register you to vote right outside the door. Please come and talk with Judge Silverman. He'll be here for a while. Thank you for being here and celebrating the Constitution.
Thank you so very much.
Thank you, Professor Lam.
Pleasure.